Thank you everyone for joining the March Talking Feds Q&A. We're really glad that everyone's here. We've gotten a lot of questions that I'll be asking, but as always, if anyone has questions while we're going, feel free to write them in the chat and I will add them to our list. Ready to get started, Harry?
I am. Hi, everybody. Thanks for coming. These things are really fun, I think.
Yeah. The first one, so there's a lot on the indictment that will be likely coming
No
shortly.
surprise.
Yep. So I'll start with those ones just to get them out of the way. First question, love talking feds. How does the misdemeanor to felony elevation process work and what kind of crimes can be connected this way? That's something you've talked about a bit in relation to this case.
Yeah, so it's just a function of New York law that a simple misreporting of income, just when a corporation does a false entry, as happened here, when they, instead of saying hush money to Stormy Daniels, they said retention agreement or consulting fees to Michael Cohen. That was a false entry. That's a misdemeanor. That's a really clean misdemeanor. But of course, it's a misdemeanor. How does it work? Under New York law, there's just another provision that says if you're doing this misdemeanor reporting in furtherance of another crime, that's all it says. It's clear that it could be the other crime can be a misdemeanor. It's pretty clear, but if Bragg winds up going this way, there'll be legal tussle, certainly, that it could be a federal crime or a state crime, but it's just got to be that this misreporting you've done, you're trying to conceal or otherwise further a different crime, and you have to prove that other crime, and then presto change, the misdemeanor becomes a felony.
How unusual is it for the defense to be allowed to send in someone else to testify to a grand jury to try to discredit a prosecution witness? I've never heard of that happening before. And maybe you can say what this is in relation to as well.
Yeah, so we thought everything was all done as of last week, and then we heard that yesterday Robert Costello was at the behest of the Trump team was going in to testify. How unusual was it? No, something I should add, because it's gonna play out for months and months to come. New York law is pretty unusual and tends to be pretty defendant friendly. So there's just a provision of New York law, it's not even a practice, that a defendant has a right to request a witness be heard by the grand jury. The grand jury doesn't have to say yes. And in fact, in this case, Trump wanted Costello to go into this whole kind of diatribe of the sort that Costello did after testifying. But really all that happened here was, and he was frustrated about it, was he was asked about 2 or 3 documents that figure in the case. So it's a routine feature of New York law that a defendant can ask. How often do defendants ask? Hard to say. How often do grand juries accept the request? Also hard to say. The big point here is Trump obviously wanted this to be very influential. I think he called Costello the most important witness there was. And when Costello was done, Costello himself being a very problematic witness. He's the guy who said to Cohen many moons ago, "You've got friends in high places, you can rest easily." In other words, wink, wink, nod, nod, don't rat out Trump and we'll get you a pardon at the end. Costello, himself was a pretty flawed witness, and it was really telling that the DA didn't even call Cohen back, as it could have, to respond to or rebut the things that Costello said, meaning that DA had concluded, I think, pretty definitively, this doesn't really change things, doesn't really hurt the case. And by the way, kind of a little boon for the DA as well to have gotten a preview of what Costello was going to say if he were to testify at trial.
Will McCarthys House investigation of the New York District Attorney's Office have any teeth, or is it just another publicity stunt?
It really shouldn't. Stop for a second and take a step back. Who the hell is what to call to the carpet a local elected DA. I can understand why Republicans are protesting or up in arms or suggesting that it matters that Bragg's a Democrat, but Bragg, their office doesn't get federal money. They really serve the people of New York and furthering the law enforcement and other interests of the people of New York. McCarthy's basically all wet in saying, calling him to testify, and even more extreme before the charges have even been filed. So I think he will drop a subpoena on Bragg, and Bragg will go to court, probably New York State court, and say, this guy's got no authority over me. We'll see how that plays out. It'll be a political tussle, but I choose answer B in the question. It is just a political stunt. Among other things, McCarthy doesn't know squat about the charges themselves, and it's just basically, like a lot of people on that side of the aisle, just asserting from the raw fact that Bragg is a Democrat, that the whole thing must be bogus and trumped up. I want to add, I think it's a tricky, sobering, something to really think about, that a local DA might indict a former president, et cetera, et cetera. But it ain't enough to say that the mere fact that he's Democrat makes it politicized or suspect. I was on CNN this morning, and it was a pretty well-known Republican spokesperson whose name eludes me now, but he said it's inevitably law and politics intertwined. But if the conclusion from that is you can't bring a charge, that's the end of the rule of law, right? So the question has to go to the merits, and are the facts righteous? Would other people be charged in similar circumstances, et cetera, and not just brandish it because it's a Democrat. And that, best I can tell, is all they've said or done so far. So I think it's bogus, and no justification at all. Remember, they're supposed to respect federalism, state power, and the like, but it's not stopping them from saber rattling and saying, come and testify to us.
We have a couple of questions on this from Terry, who is here with us right now.
Hi, Terry.
The first is, hi, Harry. My question is, can additional charges be brought against Trump for inciting protests over the indictment, as he's been doing today? Or does that just fall under free speech rights?
Great question, and we're getting a constitutional lesson, aren't we? I mean, he did something similar in January 6th, and he is, going to be free speech defense will be rejected, but the courts are really strict about it. It's not enough to rev people up. There's always that dividing line of people's sort of free will, and everything he said so far, I think, doesn't rise to the level of the Brandenburg test, as it were, inciting immediate lawlessness and violence. And indeed, actually, as best we can tell, there's been 6 people with hand scribbled signs in Manhattan and Mar-a-Lago. But to date, what he's done, I think, is safely on the line of free speech, because it's just not inciting imminent lawlessness as it has to. Great question, though. Right. And then there's a follow-up from Terry?
Yes, there's a second one, also about any additional charges. Can any additional charges be brought against Michael Cohen for any crimes he may have testified to in the New York grand jury?
There could. He hasn't gotten immunity. I don't see why they would. And he, it's actually... this comes up in another setting, but New York is able to bring charges, even if it's the same conduct that the feds already got him for. So, man, what a turnabout that would be. So, under the law, yes, because even if they grow out the same conduct as the feds charged him with, you're allowed to do that. People think it's kind of stinks because it smells like double jeopardy. But the Supreme Court's justification is, there's the United States and there's New York. They're separate sovereigns, same as the United States and, Peru. So it's sometimes witnesses demand immunity. It's pretty clear that Cohen hasn't done it here, or we would know.
Mhm.
So in the realm of possibility, but very hard to see it happening in practice.
We also have a question from Alicia, who is here, and there are actually two questions that are related, so I'm gonna ask them together. But
Okay, both from
um,
Alicia, or your
one
the two
is from
different.
Alicia and one is another one. But
Okay.
Alicia's is, are the DAs in Fulton County and Manhattan talking to each other? Seems to me that someone potentially being indicted in two jurisdictions is a logistical nightmare, and it would be in everyone's best interest for them to coordinate. And the second question is, in the event of multiple indictments going at the same time, which case comes first? Are they all tried independently of each other? Is there any coordination concerning time and resources? So that whole question.
Really excellent question. And the short answer is there's no short answer. But, this happens where, especially between the feds and state, and I've been involved in a lot of such cases, and it's generally two things happen. It's negotiated out and gingerly, and the feds go first. That's the way things tend to work. Now, here it's talk about a logistical nightmare. You're right, because I think we're looking at, Fulton County, I think will happen, and I think DOJ will happen. So we're talking about three different cases, criminal and state and federal, and two different states. Now, the only thing, and this is really important to think about generally, I don't know if you've been following the news, but it's a breathless kind of day and week, and these charges are coming very fast, and American history will change. In a sense, it will. It's a really big deal. In a sense, it won't, because what will happen in all three of these cases is a lot of pretrial litigation, motion practice, where Trump tries to persuade the court to dismiss the charges for various reasons. So in that sense, although Trump may always try to leverage it to delay things, as is his wont, there's not that much actual. When things get really snarly in cases, is when you have to have the physical possession of a defendant in order to try them, or maybe they're being they're being denied bail and that kind of thing. So, first point, just, good to remember, is none of these are happening anytime soon. And the prospect of Trump being locked up, not given bail, is next to nil also. So for now, it's just he's got, 8 cases he's fighting hard on basically meritless legal grounds, make it 10. Now, when push comes to shove, and it can also happen, by the way, at the investigative stage, that you need someone to kind of give ground, but that's about done in Manhattan and Fulton County, so that won't come up either. So there will come a time, perhaps, when it really is, Trump needs to be physically there to face charges, to testify in more than one place. And then there's a law about interstate agreement on detainers having to do with the feds and the states, and no real law as among the states, unless there's some special, New York or Georgia understanding, which I think there isn't. So logistical nightmare, very possibly, but not for a long time, and only if the dice roll in a certain way. My best guess is that the New York charges will have a pretty long lead. The Fulton County charges will have a very long lead. There's a lot of stuff they're going to have to try to work out, actually, not meritorious, but non-trivial arguments Trump can make. and the feds, always the 900-pound gorilla here, will probably be able to go first if their case is totally ripe. So really good question. Possible in theory, but more has to happen.
So I'm going to change gears a little bit. This is from Cynthia, who I don't believe is on the call, but sent it
Okay.
in. She said, I would love a perspective on the lawsuits currently in progress against abortion restrictions on religious grounds. How do the state level lawsuits possibly lead to federal lawsuits for some reason? And if it goes to the Supreme Court, maybe too soon, but I'd love to understand if it's better for these state lawsuits to reinstate some version of Roe v. Wade, maybe in the way RBG wrote about in her opinion.
Yeah. So this is really interesting. I actually tried to take a look at this recently because I know the cases have been filed, but they don't seem to have gone anywhere. There's at least one in Florida, and it's filed by Jewish clerics, or the lead plaintiff anyway it's a rabbi, and his allegation is, hey, Jewish law requires solicitude toward the life of the mother. Also, Jewish law has a definition of embryo and fetus and the like, and it's quite like viability. I think it's a term that's in the Bible, quickening, and therefore, if you don't let doctors or if you don't let women have abortion services, you are violating the free exercise rights of Jewish people. So exactly the mirror image of people who might say, I have really conscientious anti-abortion views. But the Supreme Court has been very solicitous of religious stuff. All through COVID, for example, there were these claims about people having to shut down or be at certain distances from one another. And religious folks said, that you're not letting us have church services. That's burdening our free exercise rights. And this court was extreme. I mean, was basically making new law and is on the way to making more new law about special. You have to give special solicitude. You can't do the same rules as in normal situations. Say you're discriminating against employees or older people or whatever. They're saying, religious discrimination against religious exercise gets much more serious look and can get shot down. So it's going to be, immovable object and against irresistible force if and when it comes to the Supreme Court, because on the one hand, it will. Now, there's no chance of reinstating Roe versus Wade, but the question would be, do these religious people have a right to say, Florida, you can't put in your 5-week ban because that's violating my religious rights? And what is the court going to do with that? A court that's basically hostile to abortion rights, but very solicitous of religious rights.
Yeah.
So I don't that's sets up a kind of exquisite battle that's just now in its very early stages. So we don't know how to develop. It's going to have to move all the way through the courts, and then we'll see what the Supreme Court does with it. Very interesting case.
Also on the court, term limits for Supreme Court have been suggested many times. Would you support this, and what length should they be limited to?
I always resist. I always resist, but man, I have a problem with this court that the term limit proposal would solve. In a way, we're looking at a generation or more of a monolithic conservative court that I think is just bad for the country and bad for the court. Still in all, I think I probably wouldn't support it. It's just such a radical change, and things get funky when you're at the end of a particular justice's tenure and whatever. What would the terms be? So the main proposal would that's out there, there have been a few that are bandied about, would be 18-year terms. A pretty good chunk of time. Of course, lately both parties have been trying to appoint younger and younger justices so they serve longer. other countries do it. There's a lot to be said for it, and maybe I'm just too hidebound about it. But man, what a huge change and toward politicization, it seems to me,
Mhm.
on the court. What these proposals also are often combined with a guarantee that individual presidents would get appointments. Part of what happened here with the court is just bad luck of the draw for Democrats, and Trump having three appointments, having three arch conservatives who are there for forever, as far as I'm concerned, because they're like a fair bit younger than I am.
Yeah. Here's another kind of broad legal question. Hi, I'd love to know a bit more about grand juries. First, what is the selection process like since it's conducted only by prosecutors? Are they still looking for jurors who haven't got a lot of preformed opinions? I recall Emily Corr saying she knew a little about the big lie intricacies and had never heard the Raffensperger call. Second, how many are on a grand jury? Do they come every day they're in session? Must their decisions be anonymous? So general
Man, that's a
question.
series of great questions.
Yeah.
And I could start with recommending, I think, the second ever sidebar in Talking Feds history, Talking Feds #2,
There you go.
Where Jane Lynch does a sidebar on it. But so in brief, generally speaking, states can do as they want, but generally speaking, 23 people. No to the question of what if they have prejudices or whatever. That doesn't bar them from serving in the way it would a specific trial. Indictments are just by majority vote, and it's not beyond a reasonable doubt. So that's one of the reasons people say that it's easy for prosecutors to get indictments. Normal grand juries serve for a short period, a month or two, and every day, all the crimes, bank robberies and frauds, just zoom through them. But then there are special grand juries of different types, including the one that is serving in Manhattan. They're serving 2 days a week. And you usually will take more complicated cases to them that really take a long time to develop. Because once a grand jury's tenure is done, we're seeing this in Georgia. It's done, and it's a new grand jury, and you've got to get them up to speed completely. So they can be every day, or they can be special and say 2 days a week. They're chosen by the same way you're chosen for jury duty, by the general roles. You get a summons for a grand jury, and the way to get out of it is not because of your views, but if it's going to be a huge hardship. But you need grand juries, so courts are pretty tough on that. Did I get every part of that question in there, Olivia? I
I think
think so.
so. Yeah, I
Okay.
think you
All
did.
right. All right. Good.
This one is from Jay, who is here with us.
Okay. Hi, Jay.
The Supreme Court has now heard the loan forgiveness case, but I've read about other instances of loan forgiveness, sometimes in the billions. What law permits these loans to be forgiven?
Good, really good question. And the short answer is, I mean, that's what's being fought over. But either you could have a straightforward law or you could just have what's executive discretion. So in the Trump administration, for example, it just suspended the payment of loans, didn't forgive them, but suspended. It's a similar kind of power where they, for certain, actually, I left out the lead. There are extra powers that a president has under so-called emergencies. Sometimes it's a fight. What counts as an emergency? COVID, both the Trump administration and Biden administration have called emergencies, and it's a pretty big deal for the student loan cases that just last month, the emergency ceased to be an emergency. The Biden administration said the emergency is now over. So that they wouldn't have the power to do what they did before, and what the Supreme Court is passing on in the case they heard, posing the so-called major questions doctrine. But what would have given the power is under emergencies, you can't suspend the Constitution. Well, that's a whole nother, habeas corpus, Abraham Lincoln, Civil War. But there are special powers that an executive has, and one of them, at least, the argument is the argument on the other side. No, it's too major. That's not what you can do. But there's a law that says when there's an emergency, here are some things the executive can do, and that's the law that the Biden administration looked to in forgiving the loans of certain people.
What level of crime or specific crimes does an individual need to be convicted of to be barred from running for president, Congress, Senate, Supreme Court? And what events need to occur in order to solidify the disqualification of those we know are complicit, treasonous, co-conspirators in the attempted and failed insurrection?
Wow. So great question. And the short answer is there ain't none. I mean, there's no specific constitutional bar for a felon of any sort serving in those positions. There sometimes is on state side. There is, and this goes to the second part of the question. But, for example, Trump is convicted, he's in jail. And he's then elected president. Pretty clear to me he's going to be the president, and will it be in ankle bracelets or not? We don't know. Now, if you commit a crime while in office, that can be grounds for impeachment, but it doesn't. If tomorrow Sotomayor, well, it's not name names, but they commit, then that's the remedy is impeachment for taking somebody out of office for high crimes and misdemeanors. Applies to Supreme Court justices, applies to the executive branch. All right. Now there's this special provision that the second half of the question, I think, goes to, which is the 14th Amendment, which very much recalibrated the power between state and federal governments in the wake of the Civil War, has this provision that says if you're somebody who swore an oath of allegiance to the Constitution and proceeded to make insurrection on the United States, you are not qualified to serve again in high office that requires an oath. Right? They were looking at the former union folks who wanted to come back to Congress, and it was part of that whole Reconstruction brouhaha. So that's part is a fact. Just like if you're 34 years old, you cannot be president. Just like if you don't live in the district, you cannot be a member of Congress. If you did this thing of swearing an oath and then committing insurrection, you cannot be a higher official. The toughest part nut to crack is the last part of the question. How do you show it? What is a qualified way to show it? Do you have to indict someone for insurrection and have a jury find it? Is that even enough? Can Congress vote it, as has happened in the past? And would that be enough? Is that the only thing that can be enough? Something's got to be enough, or that constitutional provision is a nullity, and it will be tested. I think it still is. There have been some, like Madison Cawthorn was challenged under this provision. As it turned out, it mooted out, but we just don't know the answer to how you effectuate that provision of the 14th Amendment. People have been suing, saying Trump can't do it for this and that reason. Does that mean a local judge just decides, oh, that was an insurrection? It's a very tricky and rich, political and legal issue.
Some more questions back to Trump. With
Okay.
any of the indictments or convictions that are coming for him, can any of them come with the condition that he has to be off any form of social media or not give interviews? And there was another question in the chat that was similar. Would they ever restrict his access to the internet or communications on the internet?
Yeah. So it's possible, but he would have to agree to it. So that's not, but people can be ordered to surrender their First Amendment rights, obviously as a First Amendment right, as a condition, a punishment. Maybe he's really getting convicted and he bargains for lesser time, but for doing this. So it wouldn't follow as a matter of course, but you can imagine the day will come when he's facing big criminal penalties and he's got to save his skin the best he can. that could be involved. But there would be a challenge even if he agreed to it, because there would be people saying my First Amendment rights are being violated, that I can't hear. It's part of my First Amendment rights to hear the words of my fearless leader here. So that would be a whole nother aspect of it, even if he agreed to it. But there are defendants who do agree, whose First Amendment rights are restricted. As with everything Trump, it's kind of a new, unprecedented context, though, for that rule.
If the Secret Service guards Trump throughout this expected indictment and future ones, how does their role affect the legal process? Who oversees their orders and actions?
Again, no straight rule, but really big and coming soon. Basically, their lookout is Trump's security and safety. And I think that's just got to yield when you walk through the door. You just can't have a fair trial. The DA would say, "What are you kidding me? You have the guys talking into their wrists and being there to protect Trump. That doesn't work out. So they have to be able to do their job, or they're at least they have to be able to be satisfied that he's going to be safe and secure. Maybe they're going to insist one of them sits in the back, or whatever. But this is part and parcel of it. The unprecedented situation of having a former president in the dock, as it were. And there are different law enforcement agencies with different lookouts. So yes, Secret Service is somehow on the job, but can't distort the basic trial. And my best guess is the deal that'll be worked out will have them kind of, hovering somewhere in the background in case they have to make a lunge at someone, but that it'll really be the local court security officials that are there when Trump is physically in court.
Here's another. Thank you for doing what you do, Harry. My question is, what are the possible punishments for someone who is convicted of treason? And do you personally think that Trump's actions are treasonous?
I mean, treason is subject to the death penalty, and I don't think his actions are treasonous just because it's a very important, definition. You've got to give aid and comfort to the enemy, basically in wartime. There's a little bit of play in the joints. What's it mean to be an enemy? So he was treasonous, in terms of uh, talking in a pub over a beer. He was really, I think, deeply betrayed his country. But treason, there's actually a constitutional provision: treason shall consist only of, and that's part of their experience in the colonist experience with the crown, that was always throwing around charges of treason to them. If anyone's seen Hamilton, that's the sort of King George thing. So I don't think it's treason, and treason is subject to capital punishment.
All right. I think this is also in relation to all of these Trump investigations. If RICO is charged, do all these cases get lumped together?
So I think I'm thinking this is about Fulton County, because it does seem as if that's something that Fani Willis is considering.
Mhm.
RICO, for just 15 seconds on it. It came about in the federal system. Racketeer, influence corp company. God, I'm getting the acronym wrong, but the idea really is for um like mob stuff, where everything is just a corrupt bit organization where they take it over. So they're looking like a legit company, but it's the garbage, everything is one big criminal enterprise. Now, the definition under law, however, is a lot narrower than that. It doesn't take all that much to you have to have a couple certain actions. And I mean, I won't go into it technically, but it doesn't take that much to charge. If they wanted to put it on that ground, on a RICO charge, they could. And the advantage is that sort of everything comes in. What they'd be alleging is the whole Trump organization, and Trump himself is just a criminal enterprise from the get-go, and they could put go back to, you name it, all kinds of things we learned, things that result the impeachment, etc. But it's harder to prove. It gets sprawling, it gets confusing to a jury. It takes a long time. You only need one vote, remember, to lose a criminal conviction. So I think the downsides to me, Fonnie Willis will make the determination, but the downsides to me of not having a clean, or as clean as possible, and direct case when you're talking about trying the former president of the United States outweigh the upsides of getting in a lot of evidence of sort of nasty stuff that's not exactly what you're charging as a crime.
This is from Ed Schneider in the chat.
Okay. Hey,
Will
Ed.
will all the now redacted evidence in the Dominion voting machines case ever be made public?
Yeah. For one, well, here's one thing that could happen. Today was the very summary judgment motions. This is a case that looks to be going to trial, and Fox looks to be in a world of hurt. One thing to note, Dominion's really swinging for the fences in damages. And you can imagine rational actors at Dominion getting together and Fox and saying, all right, we may only be worth on paper, and there's some argument, let's say, but certainly not $1.6 billion, which is what they're arguing for.
Mhm.
And Fox said, we'll write you a very big check, more damages than you're likely to get if we're liable. You can see a settlement on those grounds, but assuming it doesn't, all of this stuff, this is it's been kept under wraps because it's part of discovery in a trial, but it comes in, and yeah, you'll see witnesses trooping to the stand and being confronted with their statements. Just yesterday, they moved the court, Judge Davis in Delaware, saying we want Murdoch to testify at trial. We want Viet Din, the head counsel, to testify at trial. We want Murdoch's son to testify at trial. Those guys go in, everything they've said, unless there's some special reason for individual statements that I can't think of anything offhand. We'll see it all.
This is from Becky Stowe. What is your take on the news?
Oh, I think she's not a first time guest, I think, is my
Yes,
Becky,
no,
is that right? You've been here before. Welcome back. Hi.
What is your take on the news that just broke regarding Trump supposedly misleading his attorneys in the Mar-a-Lago case? Do you know of this news?
Well, I think I know what you mean. I mean, we could call it misleading his attorney. I believe is Becky on? So I see that she is. So just if I have this wrong, let me know. But I think what we're talking about, Evan Corcoran, he's the attorney, and he's the one who fills out, although he makes a junior attorney, Christina Voss, sign the attestation, said we did a diligent search for everything. It was a blatant lie. What just happened, and it's a pretty big deal, it's kind of the last act of the chief judge of the district court in DC before she's changed, before she's replaced by someone new who's also very good, by the way, Jeb Boasberg, that Evan Corcoran was asked about signing this and the circumstances and talking with Trump, and he said, he resisted saying that's attorney-client privilege. And the court, pretty big ruling, just said, no, I think that this is the crime fraud exception. When you were talking here, this attorney-client communication is in furtherance of a crime, namely, obstruction of justice. And so anything that you told Trump, and the documents, by the way, your emails and stuff, the Department of Justice has a right to hear. So that's a pretty big development, and the evidence will be really, I think, incendiary. We have to assume Trump is in the know. Evan Corcoran wouldn't be such a fool or such a loyalist, such a suicidal loyalist to let this happen without having guidance from Trump. So that could be very big evidence in the Mar-a-Lago, case that, after all, is about obstruction and failing to comply with the investigation and get the classified documents back. Now, I think that's what Becky may be talking about. Not exactly.
It is. She confirmed in the chat that that's
okay.
What she's talking about.
Great. All right. So I think it's pretty big. just happened last week, and now, of course, the old Trump standby, take it on appeal. So before you actually, Jack Smith is able to get Evan Corcoran back in the grand jury to fess up everything, there's going to be an appeal in the DC Circuit. How long will it take? But it's very well established that a crime fraud is reason for piercing it. And the facts seem pretty strong, and it'd be a little weird, more than a little weird, for the Court of Appeals to second guess those sorts of factual determinations. So it ought to hold up, but it might take a little bit.
Okay. And this is the last question we have today.
All right.
Harry, where do you think they will hold a former president after his conviction from any state? Is there rules around that?
I mean, no rules. If without making a prediction, just let me say that there's many steps between a conviction and the orange jumpsuit and cold iron bars closing on the former president. But should it happen, I mean, look, he's not the first guy. He's not even the first president, but he is the first American president who's been incarcerated. We had Noriega, for example, that what would basically happen is he would, it would be so imperative to protect him. There are certain, for instance, the most secure facility in the entire United States, a super duper max, actually has it's a great deal as incarceration goes, 7 freestanding little units with their own bathroom and shower, etc., because that's the only way you could protect notorious defendants. So something like that would be coming his way if, in fact, the doors slam behind him. But a lot has to. I know people dearly wish it. What would he do with his hair, etc. But what would happen is it would be the highest level, even including, by the way, even if it's a state incorporated, it's possible to incarcerate someone in a federal system. It would be the most protective, and our Secret Service around, I think, maybe, but the most protective place in the whole federal system, because for a former president to be not only incarcerated but actually harmed in some way in jail, and I think a lot of people that'd be a great way to sort of make your rep, right, would be just beyond the pale. So should it ever happen, a lot between now and then, what it'll be is the most secure and protected incarceration situation that exists in the entire country.
Okay. And we actually have one last question in the chat.
Great.
It says, one last very important question. Is that a golden retriever tail I saw pass by?
Oh, Orion Dipper. Come on. People want to say hi. Hello. We got both of them. Let me see. Come on, guys. I got 2 handsome. No, that's a golden retriever, but also a handsome black mutt. All right.
Fantastic.
Saving the most important for last. Thank you.
Yes.
All right, guys. See you next month. Fun as always.
Thanks, everyone.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.